Elections will come to order. The clerk will call the roll.
Chair Click,
Present.
Rep Cortez,
Here.
Rep Busey,
Here.
Rep Buros,
Here.
Rep Kane,
Here.
Rep Israel, Rep Middleton,
Here.
Rep Swanson.
Here.
A quorum is present. Welcome, members. It's good to see each of you here. I'm anticipating a great session. According to House rules, our committee has jurisdiction over all matters pertaining to the right of suffrage in Texas, primary, special, general elections, revisions, modification, amendment, or changes to the election code. The Secretary of State in relation to elections and campaign finance. After talking to a number of members, there's agreement that some parts of the election code are archaic. We will work to improve it. Together we will have a productive session and make great strides. I welcome your ideas on how we can make a very successful session, and I look forward to working with each of you. I do have a couple of housekeeping notes. We need to please be mindful of the number of people in the back room. We each, from time to time, need to step back to talk with staff or make phone calls. We need to make sure that there's never more than 4 or more members in the back room when you step back there. Also, remember to turn the microphone on before you speak and turn it off when your questioning has ended. We want to make sure your questions are heard. However, if they're left on, feedback can be heard online. If you would like to make any opening remarks, I'd be happy to recognize you for that purpose. And the chair would like to mention that Representative Israel is now present. Thank you. Anyone have any remarks that they would like to make? Okay. To get us started, I've invited Keith Ingram, Director of Elections at the Office of Secretary of State, to give us an election primer. He's also included in your handouts an update on HB 8, Representative Capriglione's cybersecurity bill from last session. The chair calls Keith Ingram to testify. As he's making his way up, I might mention to you that we have a glossary in your packet of acronyms that we typically use in election. I hope that you'll find that helpful. Mr. Ingram, would you please state your name and who you represent for the record?
Certainly. My name is Keith Ingram. I'm with the Texas Secretary of State's Elections Division, and I am pleased to be here today, Madam Chair and Mr. Vice Chair and Committee. Thank you all.
Great.
All right, so the Texas Secretary of State is the Chief Election Officer for the state of Texas. That means that he is responsible for obtaining and maintaining uniformity in the interpretation, application, and operation of the election code and election laws outside of the election code. However, the Secretary does not have power to enforce election laws or to investigate violations of election laws. The Chief Election Official function is exercised primarily through assistance and advice to county election officials, as well as election officials at other entities such as cities, school districts, water districts, and other kinds of election holding districts, of which in Texas we have many. Elections consist of 2 basic components, maintaining the list of registered voters as well as putting on the election itself. Both of these are primarily performed at the county level, but the state assists with the voter registration part with its federally required electronic statewide voter registration database team, as well as gathering and dissemination of data regarding the eligibility of voters on the list. County election officials are generally fall into 3 categories. You've got election administrators. They are appointed by the county election board. The county election board consists of the county judge, the tax assessor, the county clerk, and both party chairs. The elections administrator operates semi-independently. It takes a 4/5 vote of the county election board to fire a county election administrator, and they do both pieces of the election. They do both voter registration as well as the election itself. In addition, and we've got about 110 election administrators in 254 Texas counties. In other counties, county clerks generally have election responsibilities, so they do the election itself. They're elected officials who have other responsibilities. And then tax assessors generally do voter registration, and they are also elected officials with other responsibilities. And so that's the case in more than half of our counties. In a few counties, the county clerk has both voter registration as well as election responsibilities, and in some counties, the tax assessor has both, but generally it's split between the two offices. Texas has a decentralized election structure. This means that the counties and other entities holding elections do the work of having the election. It also means that they bear the expense of the election. They decide what equipment to purchase and use for the elections, with the caveat that when it comes to election voting systems themselves, they have to use equipment that has been certified by both the Election Assistance Commission at the federal level as well as our office at the state level. But other than that, they can take anything that's been certified and purchase it, as well as electronic poll books. Similarly, the decentralized nature of Texas elections means that the voter registration is county-based. This means that the county can decide whether to use Team directly for their voter registration work or to use another vendor. Currently, we have on the online side, that's what we call counties who use Team directly, 215 counties, and we have 39 that we call offline counties that use their own voter registration database that interfaces with ours overnight. It also means that the voters belong to the county and not to the state. It is the county voter registrar who is responsible for performing the task associated with registering voters and list maintenance. List maintenance is a collaborative effort between our office and the counties. The law requires that our office give the counties data regarding potential ineligibility based on death, felony convictions, or citizenship. The law requires that the counties take that data along with information from any lawful source to determine whether the voter is eligible or not. Counties are required to send a notice of examination to the voter regarding the voter's eligibility if the county election official has reason to believe that the voter is not eligible to be registered to vote. The voter can respond with proof of eligibility within 30 days or have the registration canceled by the voter registrar. Importantly, if a voter is canceled in error, so for instance, if a voter was canceled for being deceased and they show up to vote, they can be reinstated immediately. 16037 of the election code allows for immediate reinstatement, and then they vote a regular ballot. Another important piece of the election puzzle is the primary election. County political parties are responsible for the primary election in their county. The primary election is funded with a combination of general revenue as well as filing fees from the candidates. The county remains responsible for conducting and paying for early voting, including voting by mail in a primary election. However, the parties pay for ballot preparation work and the cost of election day itself. They do this with money from our office. We are required to advance the county party 75% of the election expense before the election, and after the election, the counties submit final cost reports to our office and either refund unused money or get reimbursed for remaining expenses. Changes in the last couple of legislative sessions have made it such that our office pays counties directly for the expenses incurred if they contract with the parties to run the election. In addition, our office pays the voting system vendors directly for their expenses associated with the primary election, including the preparing and printing of ballots. The federal government has historically not been very involved in the election process. The Voting Rights Act of 1965, the National Voter Registration Act of 1993, the Help America Vote Act of 2002, as well as some portions of the Americans with Disabilities Act of 1991, all have some impact on elections and voter registration processes in Texas. The Voting Rights Act ensures that there is no discriminatory practice in Texas elections. This includes discrimination based on race and ethnicity, as well as language requirements and a requirement that disabled voters have the right to be assisted by the assistant of their own choice, with two limited exceptions for their employer or an agent or officer of their labor union. The National Voter Registration Act requires states to register eligible voters and to have general programs in place to remove ineligible voters from the list. The Act made driver's license offices and other state agencies responsible for registering voters, and it required that voters be able to register to vote using a simple postcard. The Help America Vote Act established the Election Assistance Commission at the federal level and gave it responsibility for setting voting system standards, as well as certifying whether or not voting systems meet those standards. It also required every state to have a statewide electronic voter registration database for all registered voters in the state and to perform list maintenance to the computerized list on a regular basis. Finally, it required that disabled accessible voting equipment be available in every voting precinct in a federal election. Congress authorized and appropriated approximately $3 billion to award to the states so that they could implement the required electronic voter registration database as well as purchase disabled accessible voting equipment. Our office has a remaining balance of about $1.1 million of the original federal HAVA money, and we use that for team maintenance. It will pay for part of fiscal 2020, but after that we're going to need more money for team maintenance. In 2018, the Congress appropriated the final $384 million authorized by HAVA, and the EAC distributed it to the states based on population. Texas received over $23 million from the federal government and was required to fund an additional $1.1 million as a 5% match. Our office submitted its narrative and budget to the EAC regarding how we are going to spend the money. It is our plan to use a small portion for improvements to the security of statewide voter registration database. The remainder of the money will be spent to improve election security at the county level. To that end, we have worked with the Department of Information Resources and their vendor to craft an assessment of election security at the county level. The counties are required to enter into an agreement with DIR, and then they can order the assessment from the vendor. Once the assessment is completed, the county receives a report regarding issues found and their severity. Neither our office nor DIR will receive the results. However, we do intend to have aggregate data based on what is found so that we can have any training needs or policy changes that are required. I have attached a breakdown of population registered voters and voter turnout in the 2018 general election and 2018 primary election for your review. The number of registered voters for the last election was almost 15.8 million. That was a new record. The final turnout was more than 8.371 million, which was a record for a midterm election. And it was the second highest turnout in Texas history after the 8.9 million that voted in the 2016 election. I have attached for your review our report on election security that was required by HB 8, and I'm happy to take any questions that you might have.
Chair recognizes Vice Chair Cortez.
Thank you, Madam Chair. Thank you for the presentation. You talked about that the federal government had sent down some funds to each of the states. Is that correct?
That's right.
What did Texas receive specifically?
So in the first round of HAVA, we had approximately $180 million.
180 million?
That's right. And so that was from 2002, and that is the money that was primarily given to the counties to purchase accessible voting equipment with. And then last year, we received $23 million additional Title I money from Help America Vote Act.
So over 200 million has been sent to Texas?
That's right.
And your current balance is?
Of the first HAVA money, we have just over $1 million left, and for the second tranche, we have most of it left. We've spent some money at the state level, and we've performed a few of the county election assessments, but most of the $23 million is still in the bank.
So are we able to send some of those funds down to the counties to help upgrade their technology, upgrade their voting systems, update their voting machines?
Whenever we were looking at the way to get the most bang for our buck out of this money, $23 million is a lot of money, but it's not, in the larger scheme of things, very much money. So if we're talking about voting system replacement, it would be pennies on the dollar for that. So
even with the 180 million that was received previously?
That has all been spent. That was all spent in the first round in the early 2000s. In purchasing voting equipment in 2006, 2007. So that money is gone. So what we're left with is about $23 million, which is not enough to replace voting systems in Harris County alone.
I understand. And, that's something that our Bexar County Elections Administrator, Jackie Callanan, had mentioned that she's going to continue to advocate for the state to assist in helping to upgrade our voting equipment there at Bexar County. And
I understand.
Okay. Well, thank you very much for the information. Thank you, Madam Chair.
Any other questions from members? Representative Israel?
Keith, were you going to brief us on the voter purge controversy?
I'm ready to answer any questions in that regard.
Okay, well, that's a hot issue. I'm surprised, but if I have some questions about that in particular, you're okay with answering those questions in particular?
Yes, ma'am, certainly.
All right. Well, I have a lot of questions. In emails from the voter registration manager in your office to the county officials about the list maintenance exercise put forth in your recent election advisory, you say, in quote, I'm quoting, counties are not required by current law to investigate the new DPS data matches. Is that correct?
That is correct.
So this list maintenance exercise in your recent advisory was not laid out in federal statute. Is that correct?
The federal law, both HAVA and the NVRA, require our office to have a general program to remove ineligible voters from the rolls. The specific state law at issue here requires us to use DPS data for voter registration purposes. So both state and federal law require this sort of activity, and the state law specifically requires that we use this data for this activity.
The removal of duplicate records is in statute. Is that correct?
It is.
And the removal of deceased persons is in statute.
It is.
But this particular exercise is not in statute.
Yes,
This
it is. In Transportation Code 730-005.
And tell me more about the Transportation Code, because that's DPS data related?
That's right. And it requires that any data in DPS's files that's useful for voter registration be used for that purpose.
Say that again.
It says shall be used for voter registration purposes.
Okay. But this particular process is not explicitly laid out.
It's a combination of both 16033B, if a voter registrar has reason to believe that a voter is no longer eligible, as well as 16.0332, which is a test for citizenship.
But you made this process up based on what you thought the law allowed you to do.
We did not make this process up. We implemented this process because the law requires it.
Have we done anything like this before?
Certainly. We do list maintenance processes all the time.
Of this scale?
The only thing that's comparable to this scale was the Death Master file initial run back in 2012.
In 2012?
Yes, ma'am.
And what was the
Comparing.
outcome of that?
The outcome of that was that we had about 50,000 matches statewide of potentially deceased persons that needed to be investigated by the counties.
I have questions about whether or not this was actually that this list maintenance exercise was actually authorized by law. We can get into that later. I have questions about from the form that you're asking counties to send out under the advisory. Is that the only form they can use?
Yes.
Didn't you have a different form in the past?
We had a slightly different form that was limited to the jury summons process only.
Why the change in form? And what's the difference between the forms?
I can send you a side-by-side with a red line if you would like.
No, sir. I'd like to have your public comments on the record.
I
Why
don't
the
know.
different form? Because one requires documentation and the other does not.
They both require documentation. They both
Okay.
require that a person.
Explain it a little bit more.
So the only difference between the previous version of the notice of examination for citizenship and the current one is that this one is worded a little more broadly so that it's not limited to just the jury summons process. But the documents required to be shown are exactly the same.
Did DPS inform your office that they could not run citizenship checks for the purpose of voter registration against federal databases and programs?
I do not believe so. I'm generally aware that there's no such thing as a database of citizenship at the federal level, so I didn't need for DPS to tell me that.
Okay, so it was understood that for the purposes of you working with DPS, it was not for the purposes of citizenship, it was for the purposes of identity. The
I'm not
DPS
sure what you're getting
database,
at.
the DPS database was not an indicator of citizenship.
The DPS database has quite a bit of information about citizenship. I'm not sure I understand your question.
DPS is here to help us say, my name is Celia and this is who I am. not my name is Celia and I am a citizen of the United States.
No, on the contrary, the DPS has a very much a role to play in whether or not a person is here lawfully or whether they are a citizen, and they record that data and keep it.
So you think the DPS data is accurate when it comes to citizenship?
I'll let DPS speak about the accuracy of their data. We have a process in place that we use on other list maintenance processes that we apply to this data.
Okay. Madam Chair, is DPS here today? They weren't on the agenda, so I don't want to disrupt anything you might
They
have had in mind.
are in the audience, I believe. Scholar is here, I believe, as a reference, a
Okay.
resource witness. We can call him if you would like.
In a minute. Is a voter registration card an official state document?
Are you talking about the voter registration application or the certificate after
The
a voter
card
has been
that where
registered?
you apply?
The voter registration application, yes.
It is an official state document.
Yes, but there's also a national voter registration card that's slightly different that is allowed to be used in Texas, and a voter can just put the necessary information in a handwritten form, and it'll apply as it'll work as a voter registration.
And the essence of that card that's important for the purposes of our discussion is in that card you swear under penalty of perjury that you are a citizen of the United States.
That's correct.
So it's an official document, and in that document you are swearing by signature that you are a citizen of the United States.
That's right.
So those who submit a voter registration card indicating they are a U.S. citizen are updating their citizenship status within a state agency. They're advising you, the Secretary of State, the state of Texas, that they are a citizen of the United States.
That is what they're making a statement to that effect. Yes, ma'am.
Okay. So walk me through the process of the current verification of citizenship, which involves affirming that you are a citizen under penalty of perjury. Just walk me through that process right now. If I am registering people to vote, asking people to update their status, they tell me how they complete their application and how we get to the point in that application where they are saying penalty of perjury. Where is that in the process?
Well, it's on the card, so I don't know. We have applications in both English and Spanish, and it says it at the top that, you know, there's a box to check if you're a citizen, and then at the bottom it says you're swearing on penalty of perjury to the fact that you're a citizen, that you're not a felon on paper, and that you're over the age of 18.
Okay. All registrants must verify citizenship and swear and affirm that they are citizens by signing their voter registration card.
That's right.
So that process is efficient for all registrants that are currently on our database.
It is the process that's outlined by the NVRA, yes, ma'am.
So it seems like what you're telling us, in light of the elections advisory, not for folks who have ever told DPS they were non-citizens, right?
I don't understand that question.
You were telling us that this is a process your process, not a DPS process. This is you as the Secretary of State saying this is a Secretary of State process. This is not you didn't invoke DPS in any portion of this. This was simply you saying, and as an advisory to all of our county officials, that this is the Secretary of State's process, not a DPS process.
The list maintenance responsibilities are the responsibility of our office and the counties. It's a collaborative process. We've got the responsibility to provide the counties the data to use, and then the counties have the responsibility to use any lawful means at their disposal to investigate that data and determine whether or not there needs to be a notice of examination sent to the voter.
As you were preparing your list maintenance exercise, did you consider the fact that there are tens of thousands of Texans who became naturalized citizens during the course of this scope of evaluation of this data?
Yes, of course.
And those people don't have to update their records with DPS, is that correct?
They don't have to, no ma'am. But the next time they go into DPS, they will update their status. So to minimize obviously the goal of any list maintenance process is to do what the law requires, which is to make sure that eligible voters stay registered and ineligible voters are removed from the list. And so we took great care to minimize the impact on eligible voters by using our strongest matching criteria with DPS's data, so that we had as sure as you can be that the voter who we pointed out is the same person that the last time they were at DPS, not old data from DPS, but the very last time they visited DPS, they proved lawful presence. So that was our attempt to minimize the impact on eligible voters, recognizing that there is a variable for which we could not solve, and that is the persons who have since become naturalized citizens. But we are aware of the fact that counties have information at their disposal regarding persons who have registered to vote at naturalization ceremonies, and we expected the counties to use that data to whittle this list down. That is the reason why list maintenance is a collaborative process. We give them the best data that we can to the counties. The counties use that data, add to it data that they have at their disposal to make sure that eligible voters are not impacted by this. That's the reason why we told the counties to treat this as weak matches, even though they were the strongest matches we could make, so that every voter gets the benefit of the doubt.
So we've never had a sweep of this size before in Texas, but your contention is that this was authorized by the Secretary of State.
It's required by federal and state law, yes, ma'am.
Something this big and this significant, what was the rationale in including the Attorney General's office if this was a list maintenance exercise?
We also have under 31006 of the Election Code a responsibility to refer possible criminal matters if there's reason to believe that a crime might have occurred to the Attorney General, because we do not have investigative or enforcement powers, and the Attorney General is law enforcement.
But if everyone on your database signed, swore under penalty of perjury that they were a United States citizen, what was your reason to believe a crime had been committed?
The fact that the last time they went to DPS, they showed evidence of lawful presence and not citizenship, and that they are on the list of registered voters, which means that there's a potential felony for lying on their voter registration application.
Several years into the past in which they might have been naturalized since then.
That's right.
I still don't understand why the fear that a law had been broken before you actually went through the database to do some further analysis.
The point is that for that kind of investigation, that's appropriate for law enforcement, not for us.
But no laws had been broken. You did not have evidence that a law had been broken.
I had reasonable cause to suspect that a law has been broken, yes, ma'am.
How long had you been working on this project?
We began.
This is a big initiative, so I'm trying to get a gauge for.
Right, we began
timing.
working on it in early March of 2018.
Okay. What was the nexus of that idea?
There was a committee hearing for the Senate Select Committee on Election Security, and it was pretty clear at that hearing that some of the senators were not satisfied with the more reactive approach to waiting for a jury summons response for a person to indicate they're not a citizen. They would like to have had something more proactive. After the hearing, I talked to Senator Hughes and suggested to him that we had this possibility because of HB 2512 in the 2013 session, and would he help me get data from DPS?
So based on a Senate hearing, you suggested to Senator Hughes this might be an approach.
That this is something that we could do that's more proactive, that's legally required. So, and we've got the capability now with our voter registration database that we can do it.
So I'll ask you it in a different way. Because you are heading up elections for the Secretary of State's office, and as part of a Senate hearing, you suggested this as a possible solution.
That's right, as a more proactive approach to.
And by this, I mean a broad in scope analysis list maintenance exercise.
It's just using a new data source for regular list maintenance activities that are required by law.
This elections committee did not have an interim hearing, but in a course of being courteous towards one another, you sat down with me last fall and we talked about cybersecurity, Representative Capriglione's bill, and other items in and around your division. Is that correct?
That's correct.
We met in the fall. This initiative was going on several months prior. I'm wondering why this didn't come up in our conversation.
It wasn't something that we discussed. I don't know. There wasn't any reason to talk about it. I mean, people who had questions about it over the year, I've certainly responded to all their questions about it.
Who had questions about it?
Senator Huffines' office, Senator Hughes' office.
Okay. So the senators were following up with you since March about this initiative.
About list maintenance in particular with regard to non-citizens, yes, ma'am. And as part of that, I mentioned that we were working on this process.
And I, as at the time, vice chair of this committee, meeting with you about elections issues during the interim and getting a general briefing from you, it wouldn't occur to you to bring this up?
Well, it's my understanding that our meeting was in connection with the HB8 report that we had recently submitted, and so that was the focus of our meeting, and that's what we were talking about.
Okay. I think that's all I have for now, Madam Chair. Thank you. Thank you, Keith.
Thank you, Madam Chair, and thank you, Keith, for taking the time to answer questions. I just have a few follow-ups, partly off of what Representative Israel was asking. You said that this is an official, voter registration card is an official state document. So can you just clarify why that is not sufficient if it comes after the DPS document for establishing a official record of citizenship?
Because I'm not convinced that people read all the words on every document that they sign.
Okay. Isn't there a risk that we're creating a double standard for some people that once were not citizens and became naturalized citizens as opposed to everyone else that can fill out that document and not have a follow-up check?
I do not agree with that, no, sir.
Okay. Let me ask you a question. Were y'all aware when y'all had narrowed the list down to 95,000 before it went out to the counties with their specific lists that there were naturalized citizens on that list?
We understood that there was significant possibility that some of those folks had since become naturalized, yes, sir.
Okay. So before sending it out, y'all were aware of that?
Absolutely.
I guess one of my concerns is, as counties treat this differently, keeping a uniform policy across the board and making sure everyone in every county is being treated fairly and equally.
The policy is uniform. The policy requires that counties use any lawful means at their disposal to investigate whether or not a person needs to be on the list or not. That is a uniform policy. It's required by every county in the state of Texas.
Okay. I personally know, just in the last couple of weeks, I know numerous citizens on the list from my county. And also, I'm from Williamson County. In Williamson County, just in the first 48 hours, they were able to narrow this list down from around 2,000 to, I believe, around 900 in just a couple days of work. Just curious why that process wasn't done at the top level before the counties got it to make sure that they were getting more accurate lists.
Well, as I mentioned before, the list maintenance work is a collaborative process. We give the best data that we can to the counties, and then they use information at their disposal to further whittle the list down. That is the way list maintenance works in every area, and this area is no different. The only thing that's different about this is it's a large data set because it's the first time we're doing it, and it's obviously politically sensitive.
Sure. I guess a couple more things here and we'll wrap up. There clearly are lots of reports of, naturalized citizens being on the list. I mean, you agree with that. You've seen those lists and you know that they're on there.
Absolutely, and I know that the counties are doing their work to remove them. This is the way the process is supposed to work, and it is working exactly as it's supposed to.
Isn't there a concern because of the high risk that we're going to purge citizens from the voting rolls who happen to miss the 30-day notice or for whatever reason they were on this list ahead of time? Isn't that a major concern that some people will lose their right to vote?
As I mentioned, in any list maintenance process, we have competing goals. We want to leave eligible voters alone, and we want to remove ineligible voters from the list. Mm-hmm. And we take great pains to do both of those things to the extent we can at the state level, and then we train the counties to do what they're supposed to do at the county level. So we go to great lengths to try to avoid that from happening. However, it does happen, and that's why 16.037 of the election code is very important, because it allows any voter who's wrongfully canceled to be immediately reinstated when they prove that they were wrongfully canceled.
Okay, so any of these individuals, if they get removed, they can still show up, their vote will count. What do they have to do at the time when they show up to vote?
When they show up to vote, they won't be on the list. The voter registrar will say they were removed from the list because of failure to respond to a notice of examination for citizenship. So if they show evidence of citizenship, they can vote a regular ballot. They'll be immediately reinstated, and they vote that day.
Okay. My one other question. It seems that because this list of 95,000 or so that went out has so many naturalized citizens on it, wouldn't not it be a better policy to recall this advisory notice, bring it back, clean up the list before sending it back out?
I don't know how else to say what I've said. We do what we can to provide data to the counties. We do not have the data the counties have that they are using to further refine this list. The process is working exactly the way the law intends for the process to work. This is the way it goes. The only difference with this process and any other list maintenance process is that this is a larger data set for the initial run.
Okay, just one last question. Because of what we've seen with the list having naturalized citizens, is there any policy changes on y'all's end as you continue to receive data batches from DPS moving forward? I know there's an intent to continue to do this. I believe it's monthly, or is the intent. Have y'all changed policies after the wake of the last 2 weeks to maybe approach this differently moving forward?
No.
So same,
and
same policy.
the thing about
procedure.
the monthly is that a person will have gone to DPS in the last 30 days and proved lawful presence but not citizenship. So the data will be much fresher, and so the possibility exists that somebody could have been to DPS at the first of the month and got naturalized at the last of the month, but that's going to be much more rare.
All right, that's all I have. Thank you.
Members, anybody else with questions? I have a couple that I want to ask
Certainly.
regarding the whole list maintenance at the county level. Can you give us an example of what data the locals might have that you don't have?
Certainly. With regard to this exercise, they've got their voter application file, so they've got an active application file for the voter with everything that all the voter interactions. Team is a snapshot in time of the current present state, but their application files have previous activity. And so if they've got in their application files, for instance, a voter registration that came from DPS, well, then they would know that, and they would know that that's proof of citizenship. They could also have previously examined this voter with regard to citizenship and have proof of citizenship in the file. So they could have a birth certificate copy in their file or passport or whatever. The other thing that they've got access to that we don't have access to is a number of counties engage with newly naturalized citizens at ceremonies and register them to vote, and they keep those lists. So they've got those lists in their possession that they can check to see whether a voter has become naturalized and was registered at a naturalization ceremony.
So they've got a great deal of data that you don't have.
That we do not have.
Would it be fair to say that some newly naturalized citizens might take their naturalization papers with them when they would come to a county office to register to vote?
They could.
So they may have those documents as well.
In the application file, that's right.
Okay. So in the course of reviewing the data, I can certainly see why it would be a dual role when you both have differing information, and it appears that the folks on the local level have data that you would not be able to obtain in any way, shape, or form. Would that be correct?
That is correct, and that's the way the law envisions it for each of us to do our part,
So it's kind of a decentralized approach. Would that be true?
which is consistent with all the way elections are done in Texas. It's very decentralized. These voters belong to the county, not to us.
Okay. All righty. Any other questions from members? Okay. That's all we've got. Do you want to call DPS? Okay. Thank you, Mr. Ingram. The chair calls Skylar Hearn from DPS to be able to address some of the questions that Representative Israel had. If you'll state your name and your position, please.
Good morning. Skylar Hearn, Deputy Director of DPS.
Mr. Hearn, what's your role at DPS? What's your job?
I'm one of the
What areas do you include?
I oversee the law enforcement services branch of the agency, which includes the driver's license division, the law enforcement support division, which is our crime labs, crime records, communications, infrastructure, which is all our facilities, finance, cyber, IT, the training academy, and our regulatory services side, which is our license to carry and compassionate use programs, to name a few.
Okay. Would you say that the data shared with the Secretary of State used to determine that someone may be a non-citizen voter registrant is up to date? Or would you say that there's a chance this data could be dated or inaccurate?
It is up to date to the time that the individual came in our office.
Okay. What's the longest time a non-citizen could go without updating information with DPS if they have been naturalized?
That would typically be 6 years, and it would apply to a lawful permanent resident or a legal permanent resident. Their status is, because they don't have a limited term on like a visa would have, they have a full 6-year license like everyone else. So if they came into the office and got a license, they could be naturalized anytime in a 6-year period and not have to come back in to change the face of their license, because it's no different than what a citizen's looks like.
So if I'm a legal resident and I get my Texas ID or driver's license, and then I become naturalized, is there a law that says I have to come back and let you know that I've been
No, ma'am.
naturalized?
No, ma'am.
Your role is to help us identify people, not citizen people.
Well, unfortunately, we talk about with the struggles we have with driver's license statewide. 12 years ago, you came into a driver's license office to get a license to drive a car. Between state statutes starting in 2008 that required the verification of lawful presence, to all the federal statutes with Real ID that we've done over the last decade, 90% of the driver's license function when you come in is establishing your identity, your lawful presence, and giving you basically a national ID card.
Just that you are who you say you are.
10% of what we're doing in the office is licensing you to drive, and that's what's complicated that whole process and why there's such a backlog of activity.
Could a newly naturalized citizen renew their Texas ID card or driver's license without providing information to DPS that explains that they have been recently naturalized?
No, ma'am. When you come in, you will have to either establish
Let's
that
say I
you-
lost it and I've got to come back and say, hey, I need another one,
Right.
which I've done a few
Your
times.
duplicate, when you come back in, you still have to show that your presence, either you're establishing a citizenship. If we've already done that, you don't have to do that again. But if it's a lawful presence, you have to confirm that you're still valid. And we do that through a Department of Homeland Security check.
Are you confident that the data collected on citizenship is always accurate?
Again, it's accurate at the time based on what DHS provides us or the documentation that the individual provides us. If you come in, you fill out your application, and you self-report citizenship on the form, yes or no.
Yeah.
If you say yes, then we want you to provide us documentation of why that's yes, a birth certificate or some other valid form. As long as that's a valid document, you're okay. If you check no, then we need you to prove lawful presence. You provide us a visa or some other
Passport.
And then we verify that through DHS. DHS comes back and says you're good. We record that.
Are you allowed to run citizenship checks for the purposes of voter registration against federal databases and programs you might have?
No, that's not our function.
Okay, thank you.
Any other questions, members? I have a couple. There, I would think would be varying lengths of time in which you would issue a driver's license or ID. You mentioned for someone that was lawfully present or permanent resident that they would be through the regular 6-year process.
Yes, ma'am.
Are there some folks that would have a shorter duration of their license? And if so, what circumstances?
Yes, ma'am. It depends on the length of your visa, let's say you're a student and you have a 4-year student visa, the term of your license will be 4 years. Whatever validation DHS has for your lawful presence in the United States, that's the term we use up into 6 years. And if it's longer than 6 years, then you have the 6-year term.
Thank you. Any other questions? Okay. Thank you very much,
Thank you.
Mr. Hearn. Okay. Well, members, next Monday is a holiday, and we will not be meeting so that you can spend time with your families before we get into the heat of the session shortly thereafter. On Monday, February 25th, we will begin hearing bills. It will be pretty fast-paced after that. Committee staff will be sending you additional information by email regarding Elections Committee procedures. Please do not hesitate to reach out to me if you have questions or concerns, and I'm looking forward to working with each of you. The Committee on Elections is now adjourned.
Thank you, Madam